Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of visiting with Bruce Robinson of Robinson, Kennon Kendron in Lake City, Florida. Bruce is a board-certified trial attorney and has been since 1983. Bruce, thank you for joining us here today.
Pleasure to be here.
You've done a prior video for us, and I thank you again for that, and we're going to pick up where we left off with depositions. What are some of the issues you see with subpoenaing different witnesses, different types of witnesses for a deposition?
Well, one of the things that we see frequently is you have to subpoena a corporation. Remember, you can subpoena any non-party, but the notice of taking deposition of a party has the force and effect of a subpoena. So let's assume that you want to depose a corporation, the XYZ Corporation, or a governmental agency. You can designate the areas on which you wish to examine them. The organization then is required to designate one or more persons, officers, directors, managing agents, who will testify, but then they must identify what areas they will testify in. And they are required to testify as to matters that not only that they know, but are within the knowledge of their particular organization. And they have a duty to make inquiry so that they are prepared to testify, because the company is then, or the agency is then bound by their testimony. One thing I also see from time to time is people subpoena a minor child. Always remember, a minor child has an absolute right to be accompanied by a parent or guardian. Some people are unaware about that. Now, you can always take a deposition by phone too, and this is another interesting thing I've seen come up. Always remember that the person that administers the oath needs to be where the deponent is, not where the questioners are. And those are just some little issues you need to be aware of. One thing, though, that if you object in a deposition, and you're not required to, however, the rule goes on to say that if you could have objected to something that could have been cleared up there, you may have waived it. Now, we find that courts interpret that different ways in the state. Now, if you object, know that it needs to be in a non-argumentative or non-suggestive way. In other words, speaking objections are not tolerated. And let's assume that you are having your client deposed. And this is another issue we see frequently. If your witness is party is being deposed and the other side is abusive, keeps asking improper questions, you cannot instruct your witness not to answer unless your witness or the question violates a privilege, such as the attorney-client privilege. So your right to tell your client not to answer a question is very limited. If you are wrong, it subjects you to sanctions for fees and costs. But if you have the problem and the lawyer is asking questions that are abusive, insulting, or acting in an ill-mannered way, or trying to invoke or invade a privilege, what you have to do is suspend the deposition and apply immediately as you can to the court for relief.
And that's a key point when you're saying immediately, so can you touch on that a little bit?
Well, sometimes you can even call a judge and get him. Recently we had that occur where the judge actually got on the phone and ruled on the matter. But usually you can't get to a judge quite that quickly. So what you need to do is show that you have tried to get the quickest hearing you can. Don't start instructing your witness not to answer, because you're very likely going to subject your client then to monetary sanctions for fees and costs. And I find a lot of young lawyers, well, not necessarily young ones, who don't understand that. And it puts them in a bad place. So, when you do that, just know that you have to take some affirmative action. Frequently, though, what experienced lawyers do, if somebody says, I'm going to have to suspend this deposition if you continue with this behavior or to inquire into this line, usually it's an inquiry into a given line, then you can say amongst the lawyers, if they're experienced, okay, well, we will wait on that and we'll go into all the other areas. So you can finish everything but that one limited area. Now, if you have a lawyer who is just over the top in behavior, that's not going to work. You're going to have to suspend it and move for relief. Now, understand too, and a lot of people need to know this, if you put in or want to use a portion of a deposition, for example, we'll talk about parties. Non-parties are a different situation. But if you want to put into evidence a deposition, you can use it for impeachment of a witness, but you can use it against an adverse party, assuming it's relevant material. But once you do that, then the other party's entitled to have introduced any portion of the deposition that they, in fairness, think should be in evidence. So know that when you do that, you may get some of the bad you don't want as well. So, you know, depositions are used commonly now. And I like to say this to people. I see more and more long depositions. But remember, the longer it is, it's harder to get to the point you want. So sometimes it's better to get to the point more quickly, and it's more usable to me, and it's cheaper for your client. Now, if I wanted to point out this one thing that, too, remember, under our rules, you don't file the deposition with the court unless you feel it's necessary for the court in making a ruling, like in a summary judgment or something of that nature. But if you do want to do that, then you must make sure you comply with the Rule of Judicial Administration 2.425 and redact certain sensitive information. For example, in some instances, birth date, social security number. There's a whole laundry list in that Rule of Judicial Administration. What we're doing more now is getting that information off the record from opposing counsel, so we don't have to go through the deposition or other discovery with a fine-tooth comb and make sure we redact all that protected information, because that could expose you to sanctions as well.
And that's certainly a good practice tip, to go ahead and do that off the record so you don't have to deal with that down the road.
Yes. As a matter of fact, I've modified like my interrogatories so that I don't ask for that type of information, so that I don't have to worry about going through and redacting them.
Saves time later.
It does.
All right.
And it keeps you out of trouble.
Well, Bruce, you've certainly provided a lot of very useful tips and instructions on the proper use of depositions. Is there anything else that you just really think young lawyers should take away from this? Well,
you know, I was taught by an old lawyer when I started practicing. He said, always read the rule. But there's an interesting point in the rules that I have found many lawyers are unaware of, experienced ones too. If you file a deposition with the court, you have to provide a copy to all other parties who do not have a copy. They may not have bothered to spend the money to order it, but when you file it, you have to give them a copy. And that's in the rule.
Well, that's certainly something that people need to follow the rules by reading the rules, so certainly great advice. Bruce, thank you for joining us so much. You've had such great information regarding depositions. And I do encourage you to check back on a regular basis with the Mentoring with the Masters website, as we have all kinds of very good, useful information for young lawyers and lawyers alike. Bruce, thank you again.
Thank you for having me.
Absolutely.